My name is Anitya Nazmi, and my group mates are Christina, Masvita, and Fedrina. Sexual grooming offenses are not uncommon in Malaysia. However, they are rarely acknowledged due to culture and religious taboos against revealing shortcomings or offending others without acceptable evidence by law, as well as the fear of stigmatizations of the victims. As a result, some victims are silent until allegations, accusations, and reports are filed against the alleged perpetrator by others. When an adult befriends a child and forms an emotional connection with the intent of sexually abusing the child, then this is referred to child grooming. This is divided into 3 sections, which are roughly summarized as communication, grooming, and meeting in person. Under Malaysian law, Section 11 of the Sexual Offences Against Children Act 2017 deals with offences relating to child grooming. It states that any person who, sub A, sexually communicates with a child, or sub B, encourages a child to sexually communicate by any means commits an offence. A person is said to sexually communicate if, sub A, the communication or any part of the communication relates to an activity that is sexual in nature, or sub B, any reasonable person may consider any part of the communication to be sexual, and sub 3, no person shall be convicted of an offense under the section if the communication is for education, scientific, or medical purposes. Further, the Sexual Offences Against Children Act 2017, Act 792, has increased the legal violation of the law. In order to conduct an examination of the Sexual Offences Against Children Act 2017, as well as the practices some countries in combating sexual crime against children in their respective countries, a study was conducted. According to the study, Act 792 has broadened the scope of sexual offenses while emphasizing the prevention of sexual abuse against children. And indeed, such laws have been enacted in some countries around the world, including the Sex Crimes Against Children Prevention Act of 1995, which is in the United States of America, UK's Sexual Offences Act 2003, the Sexual Offences Act 2009, which is in Scotland, and the Protection of Children from Sexual Offences Act 2012, which is in India. In addition, Malaysia had the Child Act 2001, which the current law evolved from. Amendments to the Child Act 2001 made it a comprehensive law to protect children from abuse across the country in 2016. The amendments to the Act were quite comprehensive as it took into account various perspectives, including international studies and methodology to curb abuse and address the issue more effectively. The amendment is a proactive step taken by the government via the ministry to focus on caring for and protecting children in the country. In order to combat sexual offences not covered by the Child Act 2001, the government enacted the Sexual Offences Against Children Act 2017.
Malaysia has a specific statute on sexual offences against children after the UK, which has the Sexual Offences Act 2003. While our penal code does provide some limited protection for children, for instances, Section 375, which forbids the rape of a minor, or Section 377E, which forbids anyone from inducing a child under the age of 14 years old to engage in indecent acts. It is also a very outdated law, and it is insufficient to shield children from other aspects of sexual crimes such as grooming. Although Section 377E is aimed at protecting minors below the age of 14, the question that remains here is whether or not grooming could fall within the scope of this provision. Applying Section 377E to the grooming of children may be challenging for many reasons, even if the end results of the process of luring or grooming minors may amount to an act of gross indecency. First, it must be demonstrated that the defendant encouraged a minor to engage in criminal activity with him or another adult. It is difficult to define grooming precisely because a key component of the process, for instance, is talking to children, which could be justified in some situations, even though sexually explicit language is used to connect with one another and may not constitute incitement. Second, it must be established that the act was egregiously impure. It would be challenging to design a criminal offense that may implicate someone for innocent behavior due to the difficulty in determining the nature of the offense. Thirdly, the child must be younger than 14 years old. Due to this, the government decided to draft the Sexual Offences Against Children Act 2017 as a new law that addresses this issue directly. It is also noteworthy because the bill had universal support from both sides of the political spectrum when it was introduced into the parliament, which happens only occasionally. With that being said, on the 10th of July 2017, the Sexual Offences Against Children Act 2017 went into effect. This act defines and punishes specific sexual offences committed against children. It also supplements current legislation such as the Penal Code and the Child Act of 2001. Some child predators nowadays have been using cutting-edge technology to ridiculize their child grooming methods. It is no longer enough to entice victims for a date or a face-to-face meetings in order to satisfy their sick and evil desires. Innocent children are being coerced into sending naked images to the perpetrators or doing sexually explicit actions in front of a web camera in order for the perpetrator to film the act. The photographs and videos would then be used to subsequently blackmail or threaten the victims. These sad victims suffer even more terribly because of some indecent materials that are being circulated in the cyberspace and cannot be recovered, forcing them to live with the repercussions of exploitation for an extended length of time. As stated earlier, child grooming is increasingly common nowadays because most children have their own mobile phones, have access to the internet, and use telecommunication tools virtually daily. Under the Sexual Offences Against Children Act 2017, child grooming has a broad definition such that it encompasses the act of sexually conversing with a minor through any means, which includes video calls, emails, WhatsApp, WeChat, and so on. In the case of Said Naharuddin bin Said Hashim against Etika Takaful Berhad in the year 2019, it was determined that a pedophile engages in sexual grooming when he or she builds a connection of trust, affection, and friendship with a child before moving the relationship to a more sexual nature. So you might be wondering, what were the impacts of the Said Naharuddin case? Firstly, for most individuals believe that an employer should be able to fire an employee if they are involved in sexual grooming or any other sexual misconduct with a child. However, there are often ambiguities when the misconduct is based on accusations rather than a criminal conviction. So, does the principle of innocent until proven guilty apply in termination cases, or when it occurs off-site and outside of working hours despite being obviously immoral and socially unacceptable? One thing to learn from the case is that the industrial court is likely to see an employee's actions against outside of work as a wrongdoing that needs to be punished if they hurt the employer's reputation in the public eye. There are now many more ways though to fire an employee who does questionable things outside of work. However, before someone can be fired, there must be proof that the behavior in question has hurt the company's reputation as a whole. According to the industrial court, the company does not have to prove that the claimant did anything illegal or that there is enough evidence to support the charges before firing them. They also looked at the definition of sexual grooming in the Sexual Offences Against Children Act of 2017 and how serious the punishments are for it. So this case also demonstrates how bad these kind of crimes can be for the person who does them, even if they don't end up in court. Furthermore, according to Dr. Noor Zuhaida and Dr. Shahira, which are senior lecturers from USIM, regardless if it is face-to-face or online grooming, children do not grasp the nature and also the repercussions of their behavior, whether it is consented to or not. Unless the incidents include one's own family members, the public's lack of empathy and sorrow for the victims demonstrate a lack of victimology and also understanding. It is important to remember that justice must be served evenly.
The Penal Code and SOACA 2017 guide the law on child grooming in Malaysia. while in UK it is governed by the Sexual Offences Act 2003 and most recently Section 67 of the Serious Crime Act 2015. The laws are largely similar in both jurisdictions and thus generally share the same strengths and weaknesses. In both cases, the perpetrator must reasonably believe the child or victim to be under 16 years of age. However, if the child is below 13, reasonable belief doesn't apply. Also, the perpetrator must be over 18, meaning only adults can be charged. This means both jurisdictions leave a loophole in the 17-year-old range in determining how the law will deal with them as either perpetrators or victims. At the same time, there is a question of how the law treats children in sexual interactions with each other. Here, the law has to be clarified in order for there to be a stance on handling the sexual exploration of young children below 16. In both cases, the actus reus doesn't have to be in the victim's presence, as clearly explained under Section 67 of the 2015 Act and included in illustrations under Section 12 of SOACA. This reinforces the notion that the act in both jurisdictions was aimed at online pedophiles. However, this seemingly protects the perpetrators familiar to the victims, especially in the UK. Even so, the wording under SOACA attempts to be more inclusive. Further, Section 16 of SOACA allows the court to sentence someone who is in a position of trust with the victim up to 5 years in prison and at least 2 more strokes of the cane on top of whatever punishment has already been given to them. In this area, Malaysia does more to protect children from the familiar people in whom they have trust, and the government too. Remarkably, Section 19 of SOACA makes it an offense not to report abuse or intention to abuse to the police, which comes with a 5,000 ringgit fine. Malaysia is amongst the few countries in the world to have mandatory reporting laws concerning offenses against children. In this respect, Malaysia joined countries such as the USA, Australia, and Canada in doing so. This section has created a duty on all Malaysians to provide information to the police of the commission of an offense or even the intention to commit the offense. The offense created is designed to prevent sexual offenses against children in the community and ensure that people understand that protecting children and preventing sexual offenses is the responsibility of society as a whole. In terms of punishment, UK groomers face up to 2 years in prison and automatically get placed on the sex offenders register. While in Malaysia, they face a maximum 5-year prison sentence and are liable for whipping. It's commendable that there is no fine option because that would mean more financially stable perpetrators would have it easier. Malaysia, however, provides defenses for child grooming. These include science, educational, and medical purposes. However, all these terms are not defined in the new law. An additional defense of legitimate purpose related to the administration of justice needs to be incorporated into the Malaysian law in order for people acting in their professional capacity and out of necessity to be protected too. Malaysia under Section 12 goes a step further. It makes it illegal to communicate or pretend to be someone else to sexually communicate with a child, even if they never actually meet with the child. The UK law has its cracks. There is the immense difficulty of proving the requisite intention in that it is not clear as to how the clear intention is to be proved. The individual in question would presumably have to proceed sufficiently down the path of seeking to commit the offense before a clear intention to commit the offense of grooming can be made by the police. Thus, if the police are shadowing a planned meeting between the perpetrator and the child, in the absence of written evidence, in order to get evidence of clear intention to commit the offense in question, they might have to allow the perpetrator to meet alone with the child. Such a permissive approach might compromise the safety of the child and could be found to be unjustified on ethical and practical grounds. Malaysia is also not perfect, as intention is also difficult. However, Malaysian perspective is broader as the communication doesn't have to only be sexual in nature, as long as it proves the perpetrator's plans. Both Malaysia and UK are making a lot of preventive efforts through agencies and police departments. For instance, Malaysia has a special team created in 2016 for investigating online child grooming cases where children as young as 14 have been victimized. Both laws are weakly worded. The meanings of keywords like sexual are left to a lot of subjective interpretation. While SOA has no definition for sexual, SOACA gives quite a general one, albeit a much better feature. Also, mens rea for sexual intention is too general and may be difficult to get evidence for. It's notoriously difficult to prove, and hence, sometimes perpetrators have been known to walk free despite the crime being known.
In essence, the Malaysian law seems more encompassing and making greater efforts to curb child grooming, while the United Kingdom law is more focused on the sexual acts themselves, such as rape. To a larger extent, however, the laws are quite similar, and the effort that may be used to compare are by institutions such as the police and child policies to see how determined each jurisdiction is to curb child grooming and prevent perpetrators before they commit actual sexual violence on children. One strength of the grooming law in Malaysia is that under Section 19 of the 2017 Act, it states for the mandatory reporting laws concerning the offences against children, and this is a community-wide responsibility where it is a duty for all Malaysians to report or provide info to the police of the commission of the offence or someone's intention to commit the offence. However, the grooming punishment in Malaysia needs to be re-evaluated since grooming itself under Section 13 of the 2017 Act is only imprisonment maximum of 5 years and liable for whipping, and Section 14 if a meeting took place after grooming for a maximum of 10 years and liable for whipping. This is to be compared to in the United States where under the Protection of Children from Sexual Predators 1998, it is imprisonment for a minimum of 5 years and maximum of 30 years. According to a journal, the Malaysian law emphasizes on the actual face-to-face meeting of the offender to the child to be liable under Section 14, and this position is the same as in England and Wales and also Singapore. But how can that happen if it was in a situation where grooming was taking place online and assuming the parents of the child found out and reported it to the police, and the police that meets the guy at the promised meeting place instead of the child? It was also pointed out that despite the mandatory reporting law governed under Section 20, is there no exemption to the law for mothers who did not report of her boyfriend that abuses the child due to extreme fear of violence towards herself or the child, because the reality is that for some women, failure to protect and or report may actually represent a survival strategy rather than a failure. Some women only know too well that interfering with an intimate partner may have engendered only more violence towards herself and her children. In another journal, since Part 3 of the 2017 Act is subjected to Section 3 on the application of the extraterritorial application of the proposed Act, it then follows that if the offence is committed by a Malaysian citizen against a child in any place outside Malaysia, he may be dealt with in respect of such offences as if the offence was committed at any place within Malaysia. Moreover, taking as a point of reference from the Sexual Offence Act 2003 in United Kingdom, Section 14 of the Sexual Offences Against Children Bill 2017 should be referred to as meeting a child following sexual grooming, etc., as compared to meeting following child grooming as currently stated in the bill at that point of time. And in conclusion, based on the above discussions made by my learned friends above, the sexual grooming law in Malaysia is still not satisfactory and there needs to be improvements made. Thank you.